So 1 hour and a half.
We end at
It's 1 hour and a half.
1 hour and a half, yes.
Mhm.
May I start the webinar?
Just a second.
Okay.
Yes, Sibeli, please, I think we can start. Hello, everyone. Good morning, good evening, wherever you are. And hi, Adriana. Hi, Bernard. I will start the webinar now. First, I want to thank everyone for joining our webinar. This is the fourth or third, I'm not sure now, edition of a meeting organized by the Chartered Institute of Arbitrators, Brazil branch, in which we aim to discuss the main issues of the Vis Moot and Vis Moot case. My name is Cristina Mastrobuono. I'm a fellow of the SIAC and I'm the current chair of Brazil branch. I will be hosting this first seminar today, in which we will talk about the procedural issues. In today's, on Wednesday, my colleague Cesar Pereira, he's the current president of the SIAC, will host the second webinar with the presence of some stars of the Vis Moot world, Ingeborg Schwenzer and Edgardo Munoz, and with the participation of Simone Pereira, an expert in CIDES. Today, we will have the pleasure of having two real experts to talk about the procedural issues. First, we will be joined by Adriana Uson. Adriana is the director and head of Americas of the Singapore International Arbitration Center, where she leads and oversees SIAC's activities in North and Latin America. She comes sometimes to Brazil, that's why I have the pleasure to know her in person. In 2020, Adriana established SIAC's first office outside of Asia in New York. She has more than a decade of experience in dispute resolution and has served as counsel on international arbitrations, as arbitrator, and as an institutional representative. Then we have Bernard Potsch. Bernard is a lawyer based in Brazil, a fellow of the SIAC. Oh, and Adriana is a fellow also, if I'm not wrong. Yes, Adriana. So Bernard is a fellow of the SIAC. He acts as vice chair of education in the Brazil branch. He's partner at Batista Martins Advogados, has a PhD in international law, has acted as counsel, arbitrator, and tribunal secretary in domestic and international arbitral proceedings for over 10 years, on corporate, civil, and commercial matters. He teaches classes on arbitration, legal practice, and international trade, and also acts as coach for students preparing for the Vis Moot case, for the Vis Moot competition. Well, before we start with the discussions, I have to read a disclaimer here in order to protect what we are discussing about. The views and opinions expressed by the speakers during this webinar are their own and do not reflect official position or policies of SIAC. The information shared during this conference is for educational and informational purposes only and should not be considered legal, financial, or professional advice. Vis Moot participants are encouraged to seek independent guidance specific to their own circumstances. Additionally, this event may be recorded and/or photographed for promotional and archival purposes. By participating, you consent to being included in any media captured during the conference. Finally, we will not be giving you any advice about the specific case of the Vis Moot. Our discussion will be in abstract and again does not reflect the SIAC or the speaker's understanding about the issues of the case. Now, having said that, I will give you a short introduction on the case, only in the amount that is necessary for listeners to have a better understanding about what we will be discussing today. This year's case concerns a dispute arising from the termination of a sale of orchids agreement relating to the sale of orchids used for the production of vanilla. On one side, we have claimant, Orchids Worldwide, that is a medium-sized company based in Mediterranean engaged in the growing and sale of orchids. Respondent is Darwin Natural Food, based in Equatoriana, that is part of a group of companies that is one of the largest producers of natural food and spices. The agreement was signed on the 1st December 2021 between claimant and Botanical Garden, a company in Equatoriana, for the delivery of 300 vanilla orchids for research purposes. But as we can see from the case, in the interest of respondent and its business of researching, growing, and selling orchids. Now, in 2022, the Botanical Garden ran into serious financial problems, and it was taken over by respondent and became part of respondent's research facilities. On August 22, the contract was amended in 3 points only. Respondent became the official buyer under the contract. The quantity to be delivered was changed from 300 to 3,000 plus or minus 10%. And upon respondent's request, some flexibility as to the time of delivery was included. The agreement was terminated on the 1st March 2024, before orchids could deliver the products, the plants. The primary reason for the termination of the agreement was the inclusion of the vanilla orchid into Appendix 1 of the Convention on International Trade in Endangered Species of Wild Fauna and Flora, CITES, which entails the prohibition for that particular plants of any trade for primarily commercial purposes. As a consequence, respondent, as the buyer, could not obtain the necessary import permit. Claimant sold then the orchids at a lower price to another customer in another jurisdiction and terminated the contract with respondent, claiming damages for the differences in price. Now, as always, the problem has 2 sets of issues, and in each set, another 2 topics that students have to discuss. Procedurally, students have to discuss which version of the SIAC arbitration rules applies. The rules from 2016, when the agreement was signed, or the rules of 2025, when the arbitration was filed, observing also that the arbitration agreement refers to a mediation arbitration rule, and the mediation has started in 2024. Another aspect to be discussed is whether under the applicable version of the rules, claimant should be ordered to disclose the contracts with a third-party funder and after the event insurer. So these are the main issues that we are discussing, remembering that we will only address the procedural issues today. And I will start asking Adriana. And please, Adriana, feel free to amend the description I did of your career and to say a few words as introduction. But I will ask you about the rules of the Singapore Center, because one characteristics of the Vis Moot is that it alternates the arbitral institution whose rules apply to the case. And this is a wonderful thing because it provides the opportunity to the audience, to the participants, to learn more about arbitral institutions around the world and to better understand the arbitration culture of other countries. So having that in mind, I want to start by asking you about the SIAC. Could you give us an overview about important aspects of the institution, the numbers, the important features of the institution in general? So I give you the word to give us this brief introduction about the Singapore Center.
Thank you, Cristina, and thank you so much to SIAC Brazil for having me here today, and of course to all our attendees. We are really delighted that SIAC's rules are being featured at this year's Vis Moot, especially since we have just recently amended last year, and this year actually marks our 35 years. So thank you for that question. I think it's great to give a brief overview of SIAC. Especially since, this is what the students will be dealing with in the next few months. So Singapore International Arbitration Center, I was asked earlier, how do you pronounce the name? So it's SIAC, but you can call it SIAC. I mean, there's a number of ways to call the institution. So SIAC, it is an independent nonprofit arbitral institution. We provide case management services to the global business community. So we opened our doors in 1991. And in that first year, we only received actually 2 cases. But in the 35 years that followed, SIAC has grown from the small regional institution in Asia to now ranked as the world's second most preferred institution in the world, according to the latest Queen Mary University survey. So we are headquartered in Singapore, but we are also located in Mumbai, in Seoul, in Shanghai, and in Gift City, Gujarat. The most recent office that we opened is actually the one here in New York at Rockefeller Center, which covers the entire of Americas. Now, in terms of parties, Cristina was asking in terms of numbers, we work with users from over 100 jurisdictions, including actually Brazil, and across all 6 continents. As an international institution, about 90% of our cases new cases filed each year are international in nature. And more than half of that really has nothing to do with Singapore, which demonstrates the global profile of SIAC and the parties trust in our independence and neutrality. So in terms of our caseload, we have been very busy. It has been showing a steady growth year on year. Since 2016, SIAC has administered over 3,500 cases involving over 10,000 parties. We deal with both small and large complex cases. So I think the total sum in dispute right now, it approximates to $46 billion. Now, the kinds of cases that we handle are usually commercial. So last year, this was broken up mostly between trade. So you'll see sale and purchase of goods agreement, corporate. So you have those JV, M&A agreements, commercial disputes. So you'll see disputes arising, say, from services agreements, licensing agreements, distribution agreements. We also deal with construction, with shipping cases. And beyond that, the caseload really spans different sectors, such as energy, healthcare, pharma, IT, that's a growing field, telecom, mining, real estate, and so much more. Now, appointing arbitrators, it's one of our focus. It's central to what we do. SIAC maintains an international panel of arbitrators. We now have more than 600 experienced arbitrators from over 40 jurisdictions, both from common law and civil law traditions. And I would like to say that most of these arbitrators are actually fellows of FCIArb, because that was one of the requirements previously. Now, while SIAC administers arbitrations rather than mediations, we work very closely with our sister institution, the Singapore International Mediation Center. So together, we offer what we call the ARB-Med-ARB protocol, which most of you would be familiar with because it has been made reference to in the current Vis Moot Problem. So it allows parties to commence arbitration, and then the institution SIAC will hold our hands, and then we seamlessly move your case to the mediation center. Parties are given about 8 weeks to mediate, to enter into a mediation. And if they end up with an agreed settlement or settlement agreement, rather, they can go back to SIAC and ask the arbitrator, the tribunal that has been constituted by SIAC, to issue a consent award based on the terms of the agreement so that it enjoys, the benefits of the New York Convention. So you'll see more, you'll learn more. So I picked up my old copy. This is the SIMC rules, and I think it's in one of the annexes here. If you want to learn more about the protocol. So I'll pause here, Cristina, and that's a brief overview of SIAC.
Thank you so much. It's really interesting to know more about, and it's impressive the numbers you said, and also the high position that it has in the arbitral institutions ranking in the world. Yes, and I will I will ask you something that is already in the Q&A, and I invite the audience to send their questions to the speakers. I will be filtering them and trying to insert them in the speeches that will be developing here. And one of the first question from Santiago Cisneros actually is related to one of the questions I wanted to make you anyway. If SIAC has the routine of publishing awards, so how is the treatment given to awards in terms of confidentiality, and if there is a way to access a database of SIAC awards?
So for SIAC, I guess the answer is yes and no. So previously, we did publish awards. So back in 2013, we allowed the publication of awards. I think you'll see a volume. It's probably still available out there of a publication of SIAC's awards. Now, one of the things that really sorry, did you ask about the scrutiny too of awards? Is it?
No, the scrutiny not yet.
No, not yet. Okay, sorry, just the publication.
No,
sorry,
just the publication. Yes.
So previously we did. We tried to strike a balance. So with SIAC, confidentiality is really very important for us. And so previously in our 2013 rules, we had an opt-out model, which means that parties are able to, we will publish first, and then parties will just opt out if they don't want to. But then we did receive some comments, some feedback from our users that did not agree with that practice. So then what we had to do was that we had to issue, I think in 2014, a practice note saying that now we would check with the parties first. So today the position is simple and clear. Under our current rules, the 2025 rules, we only publish if it's expressly allowed by the parties and the tribunal. So it's an opt-in now. And the data really tells its own story. So we also tried to have a follow-up with those publications that we did for the EA awards. And so we ask hundreds of our parties, how many of them would agree or consent for us to publish these anonymized awards? And guess how many agreed? So
None.
actually 0.
Okay.
So that tells you a lot about what users want. So to answer that briefly, we did publish it previously, but now unless we get consent from all the parties and the tribunal, we won't publish these anonymized awards. Although what we're doing right now is, of course, trying to as well contribute to the jurisprudence of arbitration. So we're looking at publication of decisions on challenges or decisions on consolidation, for instance. But for awards, we need the consent of the parties.
Okay, thank you. Well, and going on, so the big procedural issue in this case has as a background changes of the rules, as you already gave us one of the features related to confidentiality, for instance. But what can you tell us in general? What changed from 2016 to 2025?
Well, there has a lot of changes. I think the 2025 rules really went through a very comprehensive revision. The new rules really, so I have it in front of me, the 2025 rules, it's very much the product of feedback from thousands of our users around the world. So from practitioners, arbitrators, in-house counsel, they told us what worked well, what would cause delay and what needs to change. So our aim was really not to reinvent arbitration, but to refine it. So at a high level, when we're looking at these revisions of the rules, I think it's good to keep in mind that the goal really, when we did that, was to uphold the fundamentals of arbitration, which is speed, flexibility, cost effectiveness, and confidentiality, as we've discussed. Now you'll see in Rule 3.5, it sets out our guiding principles on these rules when you're reading it and interpreting it. So first, fairness in the conduct of proceedings, efficiency that's proportionate to the dispute, and enforceability of awards. So these are our guiding principles when we wrote the rules. I can give a few highlight of the tools that we've included to design or to make the process faster and more cost effective. So these do not necessarily relate to the Vis Moot, but I guess it can show, what the institution is thinking about when we are revising or making changes to our rules. So first off, maybe some highlights. So for instance, we have the emergency arbitrator provisions. I think most of us would be familiar with that. That is a provision where if you need an urgent interim relief, you ask for an emergency arbitrator. So the difference with SIC, as amongst other institutions, is the timelines that we've put on it. So for us, within 24 hours, we find your EA, your emergency arbitrator. So we don't say as soon as possible. We don't say in 2 business days. It's within 24 hours. So it doesn't matter if it's a weekend, if it's a holiday. And the emergency arbitrator has to issue the order or award within 14 calendar days. Now, one of the things that SIC has done, it's the first institution, I believe the first major institution to have introduced this, is the ex parte protective preliminary order within the emergency arbitration proceeding. So what this means is that parties can apply on an ex parte basis to have the emergency arbitrator issue an order that will maintain the status quo until the emergency arbitrator decides the whole case. And so, this is really a solution or a response by SIC to practical problems that users raise. So one of that would be, sometimes the applicant wouldn't want to render the application moot by actually informing the other side of this urgent interim relief. We also have the expedited procedure, so most institutions would have that. That is usually what we call a fast-track procedure. So for SIAC, you need to finish, including the scrutiny of award portion, a case within 6 months. So that's expedited or fast track. Now, how it differs from other institutions is how we define what is small, for smaller value cases that goes into fast track. So for us at SIC, I think we have the highest monetary threshold in the market right now at about $7.5 million US. So any dispute below $7.5 million US will come under the fast track procedure. So you'll see from institutions to institutions that threshold will vary. Now, one of the new changes that we have introduced in the 2025 rules, apart from increasing the monetary threshold, is making the process even faster. So expedited procedure is for 6 months. We have what we call the streamlined procedure, which runs for only 3 months. Again, that includes the scrutiny process. And the 3-month process is really for the low value, low complexity disputes. So the threshold here is about $750,000 US. And the fees would be half of what you usually would have to pay for in the main proceedings. We're also one of the few institutions that have, or probably the first major one that has introduced early dismissal process. So that's a process where parties can apply for the dismissal of a claim or defense that is manifestly without legal merit or manifestly outside the jurisdiction of the tribunal. So that came out in 2016. But what we have done as an improvement as well in our 2025 rules is to include what we call a preliminary determination. So this is like early determination, but this preliminary determination is to determine issues at the outset. So not to determine whether to dismiss a claim or defense, but to determine certain issues that, if determined earlier, might actually expedite the case. And of course, we mentioned ARB-Med-ARB protocol, which we've introduced back, I think, in 2014. But I guess one of the biggest changes that we've also done in our 2025 rules, you'll see for those that are looking at our rules closely, is that we have now baked mediation in our rules. You'll see, in various provisions in SIC that we ask the parties to actually, at the very outset, to consider mediation. So whether it's ARB-Med-ARB or just mediation as a standalone, we ask that at the very start of the process. We also invite our tribunals or encourage our tribunals to raise again the possibility of mediation at the first preliminary conference. There are also provisions in the rules where we allow for the suspension of proceedings so that parties can go through with the mediation discussions or settlements. There are so many changes, but I guess the last that I would mention, because it's also relevant here in today's session, is the rule on third-party funding. So previously, you can only find the rule on third-party funding actually in our 2017 investment arbitration rules, which I had to dig and found. So this is the 2017 IA rule. So you will see this is the first time the institution has actually spoken about third-party funding. I think it's in Rule 24. And then in 2016, the 2016 rules, as mentioned in the problem, we didn't have the provision on third-party funding. But what we've done is we actually created what we call the practice note on external funding that was also issued in 2017. And the reason why we did that was, really at that time, so we didn't have it in our 2016 rules. We had it in the 2017 investment arbitration rules. And then Singapore legislation started to change. It started to allow for third-party funding in international arbitration cases. So in response to that, SIC had to issue a practice note on external funding to guide the parties in the use of that. So now another change, of course, that we've done, our 2025 rules now includes expressly for third-party funding. I guess that would be what I would highlight for today, Cristina. There's a lot of changes. We have gone online. There's an SIC gateway. We have, tribunal secretaries and all sorts of other changes.
Mm-hmm. Okay, well, but that was a very good and fast overview about really, and we can notice that there were really important changes that were introduced. Yes. Well, going further, something you talk a little bit about, but the case refers to practice notes on cases administered by SIAC. And what is the importance of these notes, and are they binding? How are they elaborated?
Well, these practice notes are very important. So you'll see under the rules, the registrar, which leads our secretariat, is expressly empowered to issue practice notes from time to time. These serves as guidance to supplement and implement the rules. So the practice notes do not replace the rules, but they sit alongside the rules and help provide clarity, consistency, and predictability in the administration of cases. So they are typically developed based on SIC's actual experience and practice. So there are things that we already do on a day-to-day basis, and we want to put that into paper so that appears in the practice notes. So based on our experience, it is also born by the feedback by arbitrators, by our users, and, as mentioned earlier, developments in international arbitration practice, such as, the external funding note that we came out with by SIC. So yes, so that's an important aspect of what we do. We look at our practice note for guidance when running our cases.
Yes, and so as I understood, the practice notes, they incorporate the rules. They are then binding to the parties that decided to adopt the rules.
Yes. And you'll see on our website, there are a list of actually different practice notes that are existing and those that are previous. And at the very start, it will say when it becomes, applicable. So it will provide whether it's a date of commencement of arbitration, when the practice notes, you'll see the relevant dates when it will take effect.
Okay, thank you. Well, I will put you on hold a little bit now, Adriana, and shift to Bernard. Bernard, so we haven't only discussed about theory until now, and you are here in charge of diving deeper into the case and actually giving some advice to the students. So what can you tell us about what arguments could be explored by the teams? So what can be developed by the teams relating to this two procedural issues?
First of all, thank you, Cristina, for the invitation to speak here today. It's an honor to be here in this panel together with Adriana. It's always a pleasure to speak with the community of Moody's and arbitrators, coaches that year after year take part in the Vis Moot. I have been involved in the Vis Moot since 2010. On the last few years, I'm not that present in coaching the University of the State of Rio de Janeiro, but I was very involved for more than 10 years with the team. So I will use a presentation mainly because this year the problem is quite based on the facts of the case. Last year we had procedural issues that delved deeper on law and rules, but these years the problems are mainly based on the facts of the case, what the parties have agreed and what if the facts of the case require disclosure of the TPF agreements. So I'll use a quick presentation. Please let me know if you are seeing it. Is that okay?
Yes, it's okay.
Perfect. Thank you, Cristina. So let us begin. And I'll first like to begin with a quick caveat. As stated on the screen, there is no single road to success in the Vis East or in the Vis Moot. There are several viable strategies to prevail on the oral rounds. So please take everything I say with a grain of salt, bring it to your coaches, bring it to your other team members, discuss it, and decide what is the strategy that best works for your team. The idea here is merely to brainstorm some ideas. We have quite a short time to discuss this, most of the time, many of those points I would discuss for hours with my Moody's in real life. So please be aware that this will be a quick brainstorm of ideas that may be used. A second caveat I would like to make is that what I'm speaking will focus on oral arguments. As you have previously submitted your respondent memo last Thursday, and considering that you are now beginning to prepare for the oral rounds, this makes much more sense. So remember that on oral arguments, time is short. You do not have the time to bring all the arguments that you brought in on your memos. And also remember that you have to be prepared to be responsive on a quite short notice. So be aware of that when drafting your strategies for the Vis Moot. But before we delve into the arguments themselves, just a few notes for those that are taking part in the Vis Moot for the first time regarding order of speakers and order of arguments. First, as order of speakers go, I have to say that it had become quite a tradition for respondent to begin on the procedural issues and claimant begin on the merits. This is not the rule set in stone. Teams are free to decide the strategy they want to apply as to the order of their speakers, but be aware that if you deviate and try to make claimant speak first on procedural issues, most likely you have to convince the other team and maybe the arbitrators that this is the proper way to do so. The second point I would like to make is order of arguments. The procedural issues here do not necessarily have to be addressed in the order the case give them to us. That means that you may, if you want, argue first for the disclosure of the TPF agreement, but be aware that particularly on the issue of the powers of the arbitral tribunal, the rules that apply are quite relevant to the argument of issue 2. So maybe, I believe most teams will opt to argue first the issue 1 and then go to issue 2. That being said, this is not a rule set in stone, so please feel free to develop your own strategies. Now, let's begin with issue 1, that is, which version of the SIAC rules to apply, the 2016 or the 2025? And before we move on to the questions that need to be answered to reach the solution of this first issue, first let's take a look at the arbitration agreement. The arbitration agreement on page 15 of the files is the following. We will not read it together here. I believe most of you have read it already, but I would just like to make a few comments before we delve into the arguments themselves. The first comment is that the drafter of the dispute resolution agreement made clear that they used the SIAC model clause as a base for the arbitration agreement that is contained in the sales agreement. And most likely the Singapore MedArb AMA clause was used, considering that, as you can see, it contains the same number of paragraphs and somewhat similar wording as to the rule. So we'll come back to the arbitration agreement later on each and every argument to be made. But moving on. We have to answer two main questions in order to answer issue 1. The first one being, have the parties agreed to apply the 2016 rules? And the second is, if not, when did the arbitral proceedings commence? Let us begin with the discussion on the applicable rules. As we said before, the agreement to arbitrate is a modified version of the SIAC model clause, with the main change in what relates to the agreement to apply the 2016 rules being the change from, for the time being, forced to the current arbitration rules. The first issue that we have is that current is an ambiguous word. It may be argued that current means both the arbitration rules valid at the time that the clause was drafted, and that it applies to the current rules when arbitration has commenced. We actually have case law both stating that for the time being in force and currently in force can mean the rules, the up-to-date rules, the rules that apply to after the commencement of the arbitral proceedings. So, at a first glance, respondent seems to have a easier task on this point. However, when we go to drafting and negotiating of the arbitration agreement, we do have some points that help claimant quite a lot. The first one is the drafter of the arbitration agreement, Ms. Nicola Globley, specifically stating that it wished to apply the current version of the arbitration rule. That would be the version acceptable to Botanical Garden at that time. Considering that at that time, the rules that were current were the 2016 rules, it is possible to argue that those were the rules that the parties agreed on negotiation. On the other hand, claimant, when deciding whether or not to agree with the draft arbitration agreement, specifically said that not only it's not a dispute resolution expert, but that the most relevant part of the clause was the possibilities of having the disputes finally resolved in arbitration. The parties, in fact, did not deeply discuss the arbitration agreement that they agreed on. It was a quite quick exchange by non-dispute resolution experts. So we do have leeway to argue both for the claimant and respondent on this matter. We do have, however, some issues that may become relevant under Article 8 of the CISG. The case file specifically states that the CISG is to apply to the interpretation of the arbitration agreement. So when we go to Article 8 of the CISG, we do have a two-tier method of interpretation, and Article 8.3 allowing the tribunal to consider all other circumstances going beyond the four corners of the contract. So what are other considerations that may become relevant? First is the CIAC rules themselves. Since 2010, the CIAC rules provide on Article 1.2 and more recently on Article 1.5 that the rule shall come into force on, as said that, and unless otherwise agreed by the parties, shall apply to any arbitration agreement is commenced on after that day. Although neither negotiators were experts on dispute resolution, it is stated, or at least it is implied, that they have read the rules. So they would have found the idea that the rules to apply absent agreement to the contrary would be the ones when arbitration commences. So this is a first point that may be argued on this issue. But we do have some other points. First is that claimant could have specifically stated that wanted to apply the CIAC rules 2016. In fact, we do have case law from Singapore that faced this issue with the CIAC rules 27 and decided that the fact that the party could have not only removed the for the time being enforced from the clause, but also mentioned specifically the CIAC rules that we wanted to apply, made it fall on the presumption that the parties agreed to apply the up-to-date rules. A second circumstance is that although the arbitration agreement was negotiated between claimant and Botanical Garden was later incorporated by respondent, and when they signed the sales agreement anew, they specifically state that the previous agreement is terminated. So there may be a point to be made as it relates to whether or not the negotiation conducted by Botanical Garden should apply here, should be considered here or not. However, please be aware that on the procedural order number 2, the arbitral tribunal made clear that respondent did have access to the emails, although it's not clear if they actually read the email from the drafter of the arbitration agreement. And also that no one contacted the drafter of the arbitration agreement after Botanical Garden being incorporated. Another factor that may become relevant is that Mr. Albios was a member of the board of the Botanical Garden when the arbitration agreement was being discussed. So keep that in mind. Maybe there's something to argue on that regard. That being said, if we find that the parties have not agreed to apply the 2016 arbitration rules, we do have to face a second question. When did the arbitral proceedings commence? And why is that not so evident in the first place? Let's go back to the arbitration agreement. As we have seen, the drafter of the arbitration agreement used the SIAC model clause specifically for the AMA protocol, but decided to put mediation prior to arbitration. However, when doing so, it specifically said, and then we can go to the negotiations, one second, that in doing so, it wanted the initiation of mediation to be treated for the purpose of the statute of limitations as constituting the commencement of arbitration proceedings. So, although the arbitration agreement in the end does not mention the AMA protocol, we do have negotiations that show that at least the intent was for it to apply and that arbitration should be considered commenced when you start mediation. However, we do have some arguments to be made on the other side. For instance, it specifically said during the negotiations that this was only for the purpose of the statute of limitations. So it is doubtful whether this would also apply to the application of the rules into force. Moreover, when the parties started, when claimant started mediation, it failed to make any reference to the AMA protocol at the request for mediation. Moreover, it is even doubtful whether or not what the drafter intended was possible. Because, for instance, both under the CIAC Rules 2016 and the CIAC Rules 2025 and the Procedural Model Law, it is expressly mentioned that arbitration would be to resolve disputes between the parties. Had the parties reached a settlement, a full settlement prior to submitting to arbitration, it can be argued that no dispute would exist to allow arbitration to proceed. So, at the end of the day, we'll have to interpret the agreement of the parties to see whether we consider the date that mediation started, that is 19 December 2024, when the rules in force were still the 2016 rules, or after 31st July 2025, when undoubtedly the rules applicable were the CIAC rules 2025. Now, moving on to issue 2, which is, shall the arbitral tribunal order the disclosure of the TPF agreements? Here we also have 2 questions to answer to reach a final decision. The first one being, has the tribunal the power to make such order? And the second, should the tribunal make such order? Just a quick recap, claimant has informed at its request for arbitration that is being funded by ATG funding, and also that it has a litigation risk insurance provider, that is Litsure, for after the event insurance. After claimant brought this information, respondent specifically asked this tribunal for the production of the TPF agreements. So this is the discussion we are having today, whether or not this information already provided by claimant is sufficient, or whether it should also produce the agreements. The first question then is, can the tribunal order the disclosure? And first I would like to begin on this argument with a caveat. You should be aware that, at least from my experience, arguments as to the powers of the arbitral tribunal are always a little hard to make on our oral arguments. They are usually received with questions, with the idea that the arbitrators should have full power to conduct the proceedings. So please be aware of that when deciding your strategy. You may argue that there are good arguments to argue that the tribunal does not have this power, but please be aware that sometimes on oral arguments, that argument is a little bit harder to make. So there are two possible rules to apply when deciding if the tribunal has the powers. The first one is the SIAC Rules 2025 that under Article 38.4 specifically provide that the tribunal may make such orders for disclosure in respect of the third-party funding agreement as it sees fit. Speaking with other coaches and other teams, I have seen some teams arguing that the final part of this article, including in respect of details, would limit the powers of the arbitral tribunal. But to be quite frank, I think this is not a winning argument. And I think that if the rules, the 2025 rules, were to apply, it would be better to argue that the tribunal should not disclose rather than that it does not have the power to order the disclosure. But if we do apply the SIAC Rules 2016, we have two things to consider. First, as mentioned by Adriana, the rules did not specifically address the issue of TPF due to the fact that at that time, Singapore was did not specifically allow for third-party funding But at the same year that Singapore became more receptive to third-party funding, the CISC released its practice note. And the practice note specifies that the tribunal shall have the power to conduct such inquiries as may appear to the tribunal to be necessary or expedient. So there's discussion to be made whether this power includes the power to determine disclosure of the documents. Moreover, you could argue for the production under the document production rules in general, that is Article 27F of the CISAC Rules 2016, that provides that the tribunal shall have the power to order any party to produce any document in their possession or control which the tribunal considers relevant to the case and material to its outcome. Maybe the bar will be a little bit higher, but it is also possible to argue under Article 27F for the production of the TPF agreements. Be aware, however, that the case has specifically stated that there is no prior interpretation of the SIAC Rules 2016 that would allow a tribunal to compel disclosure, and there is even a Supreme Court judgment upholding a CIAC award on which their sole arbitrator decided that disclosure was not possible due to the lack of powers. Now, if we consider that the tribunal has the power to make such order, we come to our last issue today, to the last question to be answered. Should the tribunal make such order? We do have a few reasons that this would or would not be necessary, but first let's look for some standards. First, let's go to the FCIArb guideline on third-party funding. On its item 11, you can see that FCIArb has specifically stated that usually early disclosure of the existence of the third-party funding and the identity of the funder is required, and mentions the ICSID, CIAC, ICC, SCC rules as examples of this fact. Here in Brazil, I can say that most of our rules regarding third-party funding usually only require you to disclose the identity of the funder, not the agreement itself. And that is because the main objective here is to try to prevent conflict of interest between the arbitrator and the third-party funding. Now let's see what we should consider to decide whether or not to disclose. I do bring here this case from New Zealand. It's not a case applying to arbitration. It is for litigation in New Zealand, so be aware of that. But it does concisely bring some considerations to be made when deciding for whether or not to disclose third-party funding. And it states that you can order disclosure on basis of abuse of process, and usually this is deeply related to the assignment of a cause of action where such assignment is not permissible, and this is deeply related to how deep is the funder influence on the case. It also mentions that this may be possible for third-party cost orders, for applications for security for cost, and that privilege matters confidentiality should also be considered in doing so. We'll face all these topics quite briefly, but one by one. Now, let's first begin why this may become relevant. The case files make clear that until June 26, 2026, claimant is still solvent, but after that date, this will become doubtful. So, it is quite possible that should an adverse cost award be imposed on claimant, it would not have the money to pay for it. And that is the reason, and also to keep it away from its balance sheets, that it sought third-party funding on the case at hand. So, let's go to those possible reasons to issue disclosure. Commencing with the adverse costs as mentioned. One point that must be considered is that respondent is seeking this third-party funding agreements to check if or not it would like to ask for security for costs in this arbitration. When doing so, procedural order number 2 brings an important information, and it seems to me, at least from reading this, that the adverse costs in the third-party funding agreement signed would come not from ATG, but from Literature. It seems that ATG does not like to include it in its proposals, the adverse cost award. So it may be argued by claimant, for instance, that the disclosure of ATG agreement serves no purpose. However, at the same time, this would mean that it strengthens the argument that maybe Literature policy may become relevant. Another point to be made is that this could become relevant because, as seen also on the SIAC guideline on TPF, that after the event, insurance can have different possibilities of policy limits. It can either cover entire costs or only a portion of the adverse costs, and that the premiums payment may be made on several different situations. So it may be that the limits are not enough to cover the adverse cost awards in the end of the arbitration, and it may be that there are payments to be made after claimant is no longer solvent. So if it stops paying after that, it can endanger the validity of the insurance. So maybe there are arguments to be made here for this production of documents. Another possible argument is that those agreements would be relevant for a possible compensation for the funding costs to be brought by claimant. But to be quite frank here, I do believe that if this were to happen, it would fall on claimant the burden of proof that those are reasonable funding costs. So I don't see much reason for respondent to argue that those should be produced for claimant to use on its argument. Another possible point is the abuse of process that we previously mentioned, that is based on funder's influence. As we can see on SIARB guideline on TPF, there are several different possibilities for funder influence, and on the case at hand, we do know that ATG Finance is particularly aggressive on several of its contracts and does usually have some influence on the conduct of the proceedings. On the other hand, we also know that the TPF agreements do not contain settlement thresholds or describe any arbitration strategies. So this may be argued for a claimant that maybe they do not have that much influence in the case at hand. Finally, we also have to consider that both TPF's agreements have confidentiality agreements. Although the confidentiality agreements allow for the production of the agreements when an arbitral tribunal orders so, it may be argued that it will, unless there are strong reasons to do so, the confidentiality agreement should be preserved, okay? I believe I am running short on time, so I will leave it with you with that. I would just like to make a final point that whichever way you choose, just remember that there are multiple roads to success. And at the end of the day, all the roads lead to Vindabona. If you have any questions, if you want to discuss any of these points with me, I'm available either here on the following part of this lecture, but also through my emails that I leave on the top of the screen. Thank you very much, Cristina. Thank you very much, FCIArb Brazil branch, for the invitation.
Well, Bernard, this is a really precious material that you prepared here, and it's really, I think it's really important for the students to have this structure about the arguments, although at this point they probably already have that. And I think what we can contribute is saying from our perspective, you for being coach such a long time, and well, I also have a little bit of experience going to the Vis Moot every year for some years now. So some advice that we can give to them. And so I was writing down, you talked about so many issues, and I will not be able to address everything. I just wanted to this last topic, the disclosure of the documents or not. It reminds me to tell the students that whenever they are presenting the case, it's always important to make the connection between the legal arguments you are presenting and the reasoning behind it. So why, for instance, the argument against the disclosure of the documents is exactly what you said. So what is the aim of disclosing information about third-party funding? Is to see whether there's a conflict of interest. Yes, so because this is one of the main issues in arbitration, not only today, but since ever, because, you know, the impartiality of arbitrators is one of the pillars of arbitration. So that's the importance of disclosing these documents, to aiming to see who is behind it, what are the economic interests, is there a conflict of interest or not? And so I think it's always important for the students to make this connection, because sometimes they start to argue, and as an arbitrator, you want to hear, so why is this important for them to disclose? Yes. And so this is just a small advice here, but also pay attention, because sometimes you enter in one argument and you see that that is playground for the arbitrator to explore in some of the aspects of the issue that aren't really that important for the case. So that there are others that are so important as that one. And you have to pay attention when some arbitrators, they really start to dive into some of the matters. And once you are there, you have to attend expectations and answer them, but start to slide away to other arguments that are also important for the case. Otherwise, for instance, the aspect of confidentiality. Yes. As we were talking last week, yes, in another meeting we were having about document production, we learned that the issue of confidentiality may not be that important anymore today. Yes, so you have to see what other arguments you may use to get the disclosure if you are defending the disclosure, arguing in favor of disclosure. So I don't want to bring more confusion here. I just want to go further, and going back to Adriana. Adriana, you already talked a little bit about it, the scrutiny of the awards. Yes. Not all the arbitral institutions provide this service for the users, for the parties. So can you tell us how does it work at SIAC?
Thanks, Cristina. You're right. So not all institutions provide scrutiny of awards, and that's something that SIC really takes pride in as a value add to our services. So we not only scrutinize the main awards, even the emergency arbitration orders are scrutinized. The awards that come out after an early dismissal application, these are all reviewed by the Secretariat. So I guess one other defining thing for us is the speed by which we do the scrutiny of awards. So for those who might not be familiar, scrutiny, it doesn't only involve looking at typographical errors or mathematical errors, but we actually go in depth with these kinds of reviews. We look at whether, there are things that might affect the enforcement of the award. So with an institution or a multinational team of lawyers, we have sort of very early on, we're looking at places where these awards will be enforced, and we're looking at the formal requirements in these places. So for instance, in Indonesia, they might need a special power of attorney, before they can enforce an award in the court. So we let the arbitrators know offhand. So apart from these things, like I said, we dive deep into the award itself. We look at whether, there was due process, whether respondents were given the chance to respond if they were, quiet the whole time. So those are the things that might affect enforcement. We look at whether the arbitrators have dealt with the issues and only the issues, if they are, whether they go beyond the issues. And again, that might be susceptible to a set aside. So we look at these things, we flag it's a conversation with the arbitrator. It's a big job, but what we do as an institution is we also take a very commercial approach in our scrutiny of awards. I know based on the feedbacks that we get that, scrutiny is an added step that can take months. And that adds to the overall timelines in arbitration. But at SIC, we actually, keep our time. We have a live tracker within our institution to see how fast we can do our scrutiny. And I think last I checked, it's 2 weeks for us to do it. So we really try to make it a fast process. So yeah.
Okay, thank you. I think as arbitrator is always good when there is a scrutiny, because it's kind of a double checking that you're not forgetting something. Yes, and for the parties, surely also, yes.
That's right, Cristina. And to just add, I think that is also one way for SIC to be able to diversify our appointments. The scrutiny actually, because we have, we have some certainty in terms of the quality of awards, we are able to entrust more of these cases to even younger arbitrations, because at the end of the day, we're working with them. While we do not influence their decision, we have to make sure, of course, that the awards that come out are quite, of a quality that SIC upholds. Another thing, sorry, that I wanted to add is the way we do it, you asked for the process, it's just 2 stages for us. So it's the counsel in charge looking at it and then the registrar. We do away with, what other institutions might do by involving the court, so the court of arbitration. And we did that because it takes time to actually clear conflicts and to get their schedule. And so far, the enforceability track record of SIC has been good with this kind of arrangement.
Great. Well, another question is related to the enforceability and the when it's a Singapore case, or the procedural aspects that may arise from an arbitration that have to be taken before the state courts in Singapore. So tell us, please, a little bit about how is this relation between arbitration and judiciary courts in Singapore? And the final question is Singapore arbitration-friendly state? I guess so, otherwise it would not be such a successful arbitral institution, but What can you tell us about it?
I'm sure, yeah. So Singapore, it was ranked as the number one seat in the world, I think, in the previous Queen Mary University survey, and it's really known as a very arbitration-friendly jurisdiction. I think you'll see that, with Singapore courts, they are consistently supportive. They take a non-interventionist approach to arbitration. So they strongly uphold arbitration agreements, respect party autonomy, and they're very careful not to interfere in the merits of the disputes. A lot of good jurisprudence actually come out from the Singapore courts. And so setting asides, they really only happen on very narrow and well-defined grounds. The other thing I can say about that too is that Singapore really has this independent judiciary with specialist judges that are very well versed in arbitration. So the Chief Justice, the current Chief Justice of Singapore, Chief Justice Sundaresh Menon, was himself an arbitration practitioner. So he very well understands and appreciates arbitration. He used to be part of SIC's board, actually. So you have judges of the Singapore courts that know and are respectful of arbitration, but Singapore has actually taken this a step further by creating what we call the Singapore International Commercial Court. So if there are cases where parties, once it comes to the enforcement or set aside applications, they don't want to do it in the local courts, they can actually agree to bring it to the International Commercial Court. And what Singapore has done in these courts is essentially to create an international bench of jurists. So the judges here are not locals. They're also international judges, and they can be the one deciding these arbitration-related decisions.
Yeah, this is really interesting. Yes, I think I don't know if there is another country that has this kind of structure. Yes. Anyway, Bernard, going back to the issues, how do you think teams should prepare and decide which arguments to rely on?
Cristina, I believe most teams have already made some pretty extensive research when they prepare the memos for the Vis Moot. So I think for the oral arguments, the most important thing in order to prepare is to be aware that you do not have the time to bring every single argument that you made on your memo for the arbitrators, particularly because you have to speak kind of slowly, you have to speak clearly. So it is important that you do have the presentation skills also on a very high bar, and this includes choosing arguments that you believe are the most relevant and the most convincing for the arbitrators. So get the arguments that you prepare for the memos and try to filter them to keep only the most relevant, the arguments that you do have the most likelihood of convince arbitrators. The second point when you do that is that you have to test and test and test once again your speech. You do have to bring it before tons of practice arbitrators. Let's say you do have to submit it before teams from your own jurisdiction, from other jurisdiction, from all across the world, because that is what's going to happen in Vindobona, either in Vis East or in the Vis Moot proper. So it is important to practice, practice, and practice. Only after that you'll be able to see what are the arguments that are convincing the arbitrators and others that are not. And sometimes you see that there are some very elegant arguments, some very creative and intelligent arguments, but that when you bring it to your oral speech, to your oral presentation, they simply do not work. Either the arbitrators do not follow what you are trying to bring, they are a little bit too complex, or maybe they face some opposition inherent to arbitrators. For instance, as I said, arguments on the powers of the arbitral tribunal usually face some resistance from arbitrators. So you do have to test and test and test once again the arguments that you filter. Cristina, if I can take the opportunity only to answer to the question by Sarah Alton that it was brought on the Q&A. Sarah, unfortunately, Sarah asks how the parties should interpret the meaning of current. I unfortunately cannot definitively answer that for you. However, as I said, we do have case law that interpret currently in force as meaning the up-to-date rules. On the other hand, so if you look at the arbitration agreement exclusively, maybe the argument for respondent is that current means the rules currently in force at the moment arbitration proceeding following the rule 1.5 from the CIAC rules 2025 or the rule 1.2 of the previous versions of the rules. On the other hand, when you go to the email of the drafter, it's very hard to argue that when it says current version on the email, it meant a version that did not exist yet. It's very clear that the drafter intended to apply the current version, meaning the 2016 rules. But however, the will of the drafter is not enough. You have to argue under Article 8.1 CIST whether or not the parties could have been aware of this. You have to argue under Article 8.2 of the CIST whether a person of the same kind under some circumstances would reach that conclusion. You have to consider that there may be an argument to be made that the change from botanical garden to respondent disrupted with what you should consider when interpreting the arbitration agreement. All that will come into play.
Yeah, this is the this is the question. The Vis Moot is not about right or wrong. Yes, this is what I always like to say, because you have always arguments in favor and you have arguments against that. So that's why these issues were chosen to be in the case. Yes, if there would be a straight and easy answer, it would not be in the case. Yes, because this is what the Vis Moot is about. So the really important thing is the way you argue in a very clear, objective manner, and stick to your arguments. Adriana, there is a question here for you. Could you read it? Can you answer it, please?
So from Cesar, congratulations, the discussion has been excellent. Is the SIACC the only court that handles cases in English, or is that available in the national courts as well? The second question is, do international arbitral award cases go automatically to the SIACC, or must the parties choose it specifically? So thanks, Cesar, for that comment. So proceedings in Singapore courts, for the first question, it's generally conducted in English, so including in the High Court and the Court of Appeal. So what makes the International Commercial Court unique, it's not so much as to the language, but I think they're specialized courts, focus on international commercial disputes and the ability to appoint international judges. For the second question, so it doesn't apply automatically. Actually, parties would have to agree to the jurisdiction of the Singapore International Commercial Court. So what we've done, if you notice, the model clause in SIC's rules have been amended to actually include a portion that says that parties, would like to refer the matter to the Singapore International Commercial Court for these kinds of issues. But there are also cases where the courts actually are the ones that move the cases from the local courts to the international commercial courts if it's within their jurisdiction. So I think those are the two ways by which you can land in the International Commercial Court.
Okay, thank you. We still have another question here from Santiago Cisneros. I think maybe this can be our last question to be answered. Bernard, can you please?
I'm muted. Santiago Cisneros asks, do you think it's more appropriate to argue that the practice note is not binding, or rather the requirements of the practice note are already met? Santiago, I think both arguments are valid to make. First of all, although the practice notes are not binding, they do generate an how can I say? They do generate an expectation on the parties that those were what the tribunal would look at when deciding. So it's the same thing when you bring case law. I think you may argue that although they are not binding on this up to tribunal, we argue that they are convincing on the standards that you should apply. But as Cristina said, sometimes you have to be ready to run for your second argument. And the second argument here is basically that, but even if you decide to apply or not to apply, the requirements of the practice note are already met. The claimant already brought the the identity of the funder. It only did not bring the contact of the funder, but maybe this can be asked specifically. And there's also an argument that maybe can be made on our arguments that disclosure as a whole is not necessary. Maybe you just need further information from the tribunal that would fall under the inquiries mentioned on the practice note. So I believe that both arguments can be made. I would not, but maybe between the two, maybe I would spend less time in stating that it's not binding, because I don't think you go very far with that. I think you should mention that, but then move on to the arguments whether or not the powers exist as a whole and whether or not the requirements are met.
Okay, so I think we are heading to the end of our webinar. Adriana, I give you the word so you can make your closing remarks.
Again, I wanted to thank SIAC Brazil for having me, and I would like to wish everyone here that's tuned in good luck on your preparations on the competition itself. I hope to see you in Vienna if you're going there. Any other questions that you might have on SIC, on the resources, and on where you can find more to research, you can reach out, although I cannot provide answers. That's why I was very hesitant to answer any questions, just for the fairness of the competition. But anything else general about SIC, please feel free to reach out. Thank you again, Cristina and Cesar, for this opportunity. And it's great to be sharing this panel, of course, with Bernard, with those, really fantastic analysis of the procedural aspect of the case.
Bernard?
Would just like once again to thank Adriana for the kind words and for being here with you today, Cristina for the invitation, and I would just like to remember all of you Moody's participating in this Vis Moot, that this is an education experience as a whole. This is not only a competition. So go there, study hard, practice your arguments, but most of the times what is most valuable that you extract from the Vis Moot is not necessarily how far you reach on the oral arguments, but the context that you made, the new friends that you make, the experiences that you have either in Hong Kong or Vienna. So please do not forget that. Take your time to go to the lectures, take your time to go to the parties and the moot bar, take your time to experience Hong Kong and Vienna together with so many peoples that are in the same vibe as you. This is a quite unique experience that you have during your lifetime. So do not forget that. Practice hard, work hard, but also play hard in Vienna and Hong Kong. Thank you very much.
Okay, we have here the presence also of Cesar Pereira. He was very quietly there watching us, but please, you can say something now.
Thank you, Cristina, and well, congratulations, Cristina, for organizing this again and keeping this tradition of having these two webinars right after the submission of the respondents' memoranda and when the teams are getting ready for the oral arguments in Hong Kong and Vienna. Congratulations, Adriana and Bernard. Thank you so much for participating and sharing all this information. And I would just like to close by inviting all of you to the second session of this series, which will take place in 2 days on Wednesday at the same time. And we will discuss the substantive issues of the problem with, as Cristina mentioned in the beginning, with Professor Ingeborg Schwenzer, Professor Edgardo Munoz, and with the specialist lawyer in the sites issues, Simone Ferreira. And so I'm very much looking forward to talking with all of you, and I hope we will have as an engaged audience as this one that we had here today. Thank you so much, and congratulations again, Cristina, Bernard, and Adriana.
Well, I also thank you, Tri, for being here. Adriana, thank you so much for, just being here, and Bernard, for all your insights you gave. And I want to draw attention to the students that are watching us that you can join the Charter Institute of Arbitrators as a student with a free membership. So you pay nothing and you can join one of the most traditional and important arbitral institutions in the entire world. So we are more or less 20,000 members, around 40 jurisdictions. So please enter the website and join the institute. And this webinar will be, the video will be available on YouTube. We will distribute it also on LinkedIn and social media. So please send it to your colleagues, or not, if you don't want them to have all these insights. But you will be free to watch it again and then pay attention on what was brought here. So thank you very much. See you on Wednesday. And Adriana and Cesar, see you in Vienna. Bye-bye.
Bye.
See you. Thank you.